Hello, welcome everyone. Welcome to our webinar today. We're going to go ahead and get started. Today's topic is debunking popular Medicare secondary payer myths, what you've heard and versus what's real. This is one of my favorite types of topics to discuss because there's so many misunderstandings in the MSP industry. And I'm delighted to debunk those myths here today with my fabulous panel. Joining me today is Brendon De Souza. He's Sanderson Firm's Chief Legal Officer. We also have Annie Davidson, who is our Senior Vice President of Legal Affairs and Compliance. I'll allow them to introduce themselves in a moment. For those of you that don't know me, my name is Heather Sanderson. I'm the founder and CEO of Sanderson Firm. I've been specializing in Medicare Secondary Payer for nearly 20 years now. Delighted to have founded Sanderson Firm and to be known as one of the fastest growing Medicare secondary payer providers in the space. I think we're truly doing things a bit different here and providing innovative strategies for you to settle your Medicare claims without headache or ridiculous expense. So, thank you again for joining us today. Just two housekeeping items also. First of all, if you have questions, we're happy to take those probably at the end of the presentation. Please feel free to type them into the chat or the Q&A function. Also, there'll be a survey at the end of the presentation. We would love it if you could fill that out and share your feedback with us. Thank you so much, and I'm going to turn it over to Brendon first to introduce himself.
Hello, everyone. My name is Brendon De Souza. I'm the CLO here at Sanderson Firm, where I manage our awesome legal department. I've been in the Medicare Secondary Pay, Service space industry since 2018, where I worked at a large national provider of Medicare Secondary Payer services. And I fully agree with Heather. This is one of my favorite webinar topics or types to host. I think there's a lot of good information in here, so I'm excited.
Awesome. And I'm Annie Davidson, Senior Vice President of Legal Affairs and Compliance here. Very excited to be with you. My background, for those of you who haven't met me before, I was a work comp insurance defense litigator at a mid-sized firm in Minnesota before I kind of caught the MSP bug and became a nerd in all things Medicare secondary payer. So like they've said, this is a fun topic. Will be really engaging. So thanks for joining us.
Great. Thanks, Annie and Brendan. Okay, just a bit about Sanderson Firm. So all we do is Medicare secondary payer. We specialize in it. We are proudly a woman-owned business certified by the Women's Business Enterprise Network. We have a national footprint across the country. We service clients in nearly every state. We do work with third-party administrators. We work with self-insured Fortune 100 companies and self-insured entities. We work with governmental entities. Basically, anybody that needs Medicare secondary payer services, we are here to assist. Our over 50 team members at Sanderson Firm are comprised of legal, clinical, and claims professionals. I'm really, really proud of the amazing team that we've built collectively here. We recently ran an analysis and we have over 500 years of experience collectively across our over 50 employees. So lots of experience here to assist you all with Medicare secondary payer compliance. All right, let's dive right in and talk about our first myth. All right, so myth number one, and this one is certainly a very important one, which is why we put it as myth number one, because this is relevant from a time perspective, but let's dig in. So, myth number one, the parties do not need a Medicare set aside when the total settlement amount is less than $25,000. So, let's talk this through. Since Medicare started their voluntary MSA review process, Medicare did implement workload review thresholds, right? These are standards in which Medicare will or will not review a Medicare set aside. And again, they're called workload thresholds because, the staff at Medicare at CMS is not endless and they can only review so many MSAs. So the two workload thresholds that have been in place for a long time is the claimant's a Medicare beneficiary and the total settlement amount is greater than $25,000, or the claimant has a reasonable expectation of Medicare enrollment within 30 months of the settlement date, and the anticipated settlement amount for future medical is expected to be $250,000 or greater. And what's important to understand is that CMS's workload review thresholds are not, nor have they ever been safe harbors. Nothing makes me cringe more than when I hear of someone saying, we're going to settle this case for $24,999. Oh, what a bad idea that is. Number one, again, CMS's review thresholds are not a safe harbor. And even still, their review thresholds are not mandatory and they've never been. So even if you settled that case for a dollar more for $25,000, Medicare can review the MSA, but they don't have to. So I've always kind of felt this was the wrong way to gauge whether you need an MSA or not. So generally, you do need an MSA regardless of the settlement amount if you have the following circumstances. Future medicals are being released. The individual will require claim-related Medicare-covered medical care, or the individual claimant is either a Medicare beneficiary or has a reasonable expectation of becoming a Medicare beneficiary within 30 months of the settlement date. So, again, if you take anything away from this presentation, understand that CMS's Medicare set-aside workload review threshold for submission are irrelevant as to whether to determine whether you need to fund a Medicare set-aside. And now let me tell you about the reasoning why this is so time sensitive for you all to understand this. So many of you are aware that Medicare began the requirement for workers' compensation insurance payers to report MSA information on all settlements over $750, right? This started just a few months ago on April 4th of 2025. So now Medicare has visibility into whether you've provided for an MSA on all Medicare beneficiary settlements over $750. Essentially, Medicare is now looking at that difference, right? If you've got a settlement under 25,000 or but greater than $750 and you haven't done an MSA because you've set your threshold of $25,000 is the minimum settlement in which you need an MSA, you're exposing yourself and perhaps the Medicare beneficiary as well. So we've come up with a new product here at Sanderson Firm. We just released it with the Medicare set-aside reporting. This might interest you for your lower dollar settlements with Medicare beneficiaries under $25,000. It's called the Abbreviated Medicare Set-Aside, or AMSA for short. These are funded low dollar allocations. We just need to look at 1 year's worth of medical and pharmacy records. We write the MSA to evidence-based standards by our in-house experts. And again, these are for Medicare beneficiary settlements under $25,000. And the benefit of the AMSA, of course, it's a little bit lower of a price point on the actual MSA preparation. And then it allows you to settle your case and demonstrate protection of Medicare's interest on those low dollar, below $25,000 settlement cases with Medicare beneficiaries. If you have interest in this product and you've not received information about it before, please let us know.
Okay, so myth number two. All right, so myth. Non-submits, otherwise known as evidence-based, otherwise known as non-CMS approved MSAs, are not supported by CMS and are not legitimate. So this is definitely on my personal top 3 myth list. This is certainly not the case. So a lot of this really stems from Medicare's policy guidance that they drafted back in, I believe it was January of 2022, where CMS, for the first time in writing, addressed the practice of settling workers' compensation claims involving Medicare beneficiaries, where the settlement would be, let's say, more than $25,000. So it meets submission thresholds, and the parties simply opted voluntarily, as they have the right to not submit that Medicare set aside to CMS for review and approval. And CMS, for the first time ever in writing, when they addressed this, they said, "Hey, look, if you settle your claim with a non-CMS approved MSA, then CMS, quote, will deny benefits to the Medicare beneficiary because CMS can't be sure that that Medicare set aside amount was actually sufficient." So about a month later, CMS hosted a town hall webinar where they essentially verbally walked back their language. Of course, they're saying one thing verbally, but they're saying another thing in writing. And so within 2 months of that, they also updated their written policy guidance to change the language. And the language went from CMS will deny benefits if a non-CMS Medicare set aside is used to CMS may deny benefits, but CMS may only deny benefits if, one, the Medicare set aside wasn't appropriately calculated in the first place, or two, the Medicare set aside funds were misspent. So for the longest time, CMS position has been unchanged. It is unfortunate though, because it's not uncommon for me to come across attorneys, judges, e- entire jurisdictions, or I should say, I should say jurisdiction, not plural. I feel for anyone out there who routinely handles Tennessee comp claims, because in Tennessee, the Tennessee Work Comp Commission has said their actual policy is, if you're settling a work comp claim with a Medicare beneficiary and it's settling for more than $25,000, then the Tennessee Commission, regardless of what venue you're in, will refuse to approve that settlement unless that Medicare set aside is actually submitted to CMS. And without getting too deep into it here, we are trying to work on the back end to get that Tennessee policy changed. But it's unfortunate this myth is still out there. But to the extent that you hear that CMS submission is not supported, that's not the case, right? Like there's no law or regulation requiring parties submit a Medicare set aside to CMS. And CMS, by its own admission in their reference guide, state that when they are reviewing MSAs that are submitted to them, they review evidence-based standards in calculating the appropriate MSA amount. So non-submit MSAs are definitely on the up and up. That's for sure. So moving into the next slide, we actually have a product to address this scenario, which is called the IMSA. It's the Indemnified Medicare Set Aside. So to the extent that you're settling a claim with a Medicare beneficiary or non-Medicare beneficiary, regardless of what the total settlement amount is, we will prepare a Medicare set aside on that file using evidence-based medicine. It's an allocation that's not submitted to CMS. But of course, we agree to indemnify. So if CMS some years down the road says, hey, this Medicare set aside report that Sanderson prepared was insufficient, we'll step in and we'll defend and we'll pay for the cost associated with that claim, such that all parties are protected. And by all parties, I really do mean all parties. So whether that's the claimant, claimant's attorney, defense counsel, carrier, co-carrier, TPA, employer, anyone and everyone who's a party to the settlement will receive the benefit of our indemnification. So don't feel scared of the non-submit MSA alternative.
I just want to add one additional thought to all of this discussion, Brendon, is that for those of you that are not aware, the Supreme Court overturned what's known as the Chevron Doctrine. And what the Chevron Doctrine essentially said was that automatic deference was given to governmental agencies to the extent that they interpreted the law. That was overturned. So now we have a state, I'm very much simplifying a topic for the purposes of time. But what the overturning of the Chevron Doctrine now means is that agency interpretations of the law, such as CMS's interpretation of the MSP in their WCMSA reference guide, are now not automatically going to be accepted by courts. So what does that mean in further simple terms, Brendon, right? We have an even stronger position behind non-submit MSAs because arguably CMS's section 4.3 always was not in line with the MSP regs, and it's a ridiculous interpretation of the law. They could never mandate, what is known as a voluntary process. Any additional thoughts there?
Yeah, so just to tag on to that, I think a lot of people, and I think because Tennessee at one point was a jurisdiction that allowed approval settlements with these non-CMS approved MSAs, and I think my sense was that that jurisdiction and just others generally were scared of the possibility that CMS could. I mean, what happened back in 22? CMS sort of woke up one day, no notice, on a whim, based on whatever direction the wind blew, said, okay, yeah, we're no longer allowing these non-submit MSAs at all. And so entities are afraid of that. But you raise a great point. Like CMS needs to account for this new doctrine, and what CMS's policy isn't exactly binding and can be challenged, right? Because courts, it is emphatically the province and duty of the court to say what the law is, right? Like that famous Marbury versus Madison Supreme Court case. So CMS is very much in check, and so definitely don't be afraid of these non-submit MSAs.
I love it. All right, myth number 3. CMS will not approve $0 allocations and hasn't for years. So for many years, I've heard this from clients that I've worked with, and It seemed to be coming from maybe some vendors who might not do a lot of submissions. $0 allocations have existed since the inception of the program, and CMS has reviewed them up until today. Today, this myth becomes a reality. They will not review and approve $0 allocations anymore. But up until today, this was absolutely a myth. So this was a tricky one, right? They were trying to get you. They, made it very difficult over the years to get approved what we call legal zero MSAs where you hadn't spent any money on medical payments or indemnity payments, but gone is that whole administrative issue that you were dealing with and trying to jump through their hoops. So it was a very cumbersome process. Despite that, they did continue to review and approve them until today. In January, they released a reference guide that said effective today, July 17th, CMS will no longer accept or review WCMSA proposals with a $0 allocation. And entities should consider the following parameters in determining whether a $0 WCMS allocation is appropriate and maintain documentation to support that allocation. I am going to walk through that here in just a second, but before I do that, I am currently serving as president of the National MSP Network, and just this morning we met with CMS. And for many of you in the industry, you might have heard some rumblings about CMS inquiring about $0 allocations in light of what Heather talked about, the reporting of MSAs in any settlement that is for more than $750. It's true, Medicare's EDI reps were reaching out to authorized reps at the responsible reporting entities, mostly just to kind of gather information and find out if the reporting was indeed accurate. There are some unintended consequences flowing from the implementation of the WCMSA reporting fields that Heather mentioned that went into effect on April 4th. CMS is aware of them. They are working on them. They are trying to build more nuances into their system. But if you've been impacted by that, that's what's going on. It wasn't their intention to scare folks, but it definitely had a ripple across the industry. So more to come on that, but that is truly breaking news. So wanted to share that with you. Okay, so let's talk about the indications. Why might Medicare be reaching out to find out if this is an accurate report? Well, one, because they try to kick out correspondence to the claimant post-settlement, and once they get your reporting data to say, hey, look, we're aware you've had a settlement, and in this case, it would be that they have a $0 allocation. If you're a little bit more skeptical, like Brendon might be, we were talking about this before we got started, he's thinking like any good attorney, right? What else are they going to do with this information? Are they teeing this up for audits or what? Yeah, I think that might be the case. For those of us who've been in meetings with CMS over the years, over the last year and a half, 2 years, as they were looking to implement these reporting fields, $0 allocations absolutely came up. And CMS had said, yeah, we might want to reach out and ask you or audit you eventually if we see a $0 allocation and a really high TPOC amount. Of course, the attorneys in the room, the claims handlers in the room, were all saying, hey, look, this means you don't understand exposure. There may be a perfectly reasonable reason to settle a case in the six-figure range with a $0 settlement. I have handled those cases in the past. You think about an intoxication defense. Person made a really poor choice. They fell down some stairs delivering some pizza while drunk at work. It would have happened whether they, if they weren't at work, that's on them. The Medicare program always should have paid for that. Is the carrier still going to settle it and pay a hefty price maybe because of exposure in the jurisdiction? Possibly, but there's no future care there that should be borne by the carrier. So if you're going to, in the past when you were submitting these, it was never required, you could submit them, but they said the facts of the case would have to demonstrate that you're not going to pay for any of those past medical expenses. So that needs to be present still today. And there can't be evidence that you're attempting to maximize other avenues or aspects of the settlement. So maybe you're settling, the medical for $0 and then beefing up the indemnity or something. You can't be trying to get cute. And that's going to run you into False Claims Act stuff anyway. So please don't do it. So these two criteria have to be met. And then if we move to the next slide, one of the next 4 criteria should be met in Medicare's eyes. So the first one is the individual's treating physician documents in the medical records that to a reasonable degree of medical certainty, the person no longer requires future care with regard to the settling injury or illness. That's what we've traditionally called a medical zero. The doctor writes something or there's something in the medical record saying no future care. You're good to go. You document your file. You're good. They added this next bullet point, and this one kind of gets at legal zeros. So the carrier or self-insured denied responsibility for the claim, and they have made no medical and no indemnity payments except for maybe investigational purposes prior to the settlement. And those medical indemnity benefits are not actively being paid. The settlement agreement doesn't allocate certain amounts for specific future or past medical or pharmacy services as a condition of the settlement. So this is really kind of the legal zero world that we lived in. It was always sort of, you know, out there, but it had never been codified before. It was never anywhere in writing. So we've got it in writing now. This is a basis that they recognize if you'd want to document this as well. On the next slide, we've got the other two criteria. So again, if one of these four need to be met in Medicare's eyes, kind of meet that standard for a zero. A court or commission or board, whatever is in that competent jurisdiction, right? They've issued a final ruling on the merits indicating that the injury has resolved and, you know, the person doesn't need any future care, or maybe basically the carrier or self-insured employer doesn't owe any additional medical or indemnity benefits. They're not actively being paid, and the settlement agreement doesn't allocate certain amounts for future medical services. This has been called a medical zero in some places and a legal zero in other places. It makes sense to call it a legal zero because the courts are issuing it, but either way, no future care. That was in the reference guide before too, and you want to document your file. The next one though is again a new bullet that they introduced in January, and it falls along those legal zero. Oh, if we can go back one more slide. Yep, thank you. So the workers' compensation and the insurer or self-insured employer does that within the statutory time frame allowed to pay without prejudice if that's allowed in the state. So you think of states like California or Florida, right, during the investigation period. The benefits are not actively being paid, and the settlement agreement doesn't allocate certain amounts for specific future medical services. So this kind of gets at that pay without prejudice time period and codifies that as well. So the third bullet point that I talked about on the last slide, that one is kind of more, a little bit more lenient than this last one. This last one is what most of us lived with when legal zeros weren't codified in writing. So you've got two avenues to it now. Make sure you're documenting it. That's definitely from CMS's mind. We can move to the next slide now. One of the other things we did since I came on board here, it's something I've always wanted to do, was indemnify proper zero allocations. And Heather and Brendon are awesome, and they are great legal minds, right? They get it too. So why wouldn't we indemnify a situation that meets any of those criteria? Again, you can't be, you know, trying to maximize other avenues of the settlement and things like that. But if you're in good faith, have a reason to do a zero allocation, by all means, Sanderson firm is going to stand behind you. It's total cost savings versus a standard, right? Because we're allocating $0. Again, we're indemnifying all of the parties, and we're protecting you from that challenge by Medicare in the future. And we've started to see it, right? Some phone calls have been happening. So if this is something that interests you, please get in touch with us, because we
Annie, we can't hear you.
Nope, still silent.
I think we can hear you better without the headset.
Okay.
There we go.
You can hear me now?
Yeah, maybe
Okay,
back
my
up
headset
a few
must-
sentences.
Yep, I will do that. Thanks, everyone. Thanks. My headset must have died. Yeah, so I'll just take it back a couple sentences, right? We will indemnify all the parties. Medicare started making calls, right? So a good time to have Sanderson firm on your side to be walking you through this and helping you. It still reasonably recognizes Medicare's interest under the Act, because under the Act, we have to reasonably recognize Medicare's interest. That's all that it sort of equates to when you translate the Act itself into plain language. And so that's what we're doing. It can be used whether the claimant is a current beneficiary or simply has a reasonable expectation of becoming a beneficiary within the next 30 months. And then the other piece is we're going to utilize relevant case facts, state law in conjunction with that criteria outlined. And also, while Medicare has outlined those 4 bullet points, like Heather and Brendon were just talking about with the Chevron doctrine, their opinion matters, but it doesn't matter as much as it used to. So there may be other ways to get to a 0 that make sense, that you can defend based on your state law. Talk to us about it, because this is very important. You don't want to just fund allocations for denied claims when you don't have to. And we've heard some entities talking about that, saying, oh, we're not going to do zeros anymore because we like to submit. And think about Tennessee. You can't, Brendon can work some magic and get them to kind of see the light there, right? So it's really important not to lose sight of this. It's a tool in your toolbox. I needed it when I was a defense attorney. I absolutely use these in the right cases. So we have a good product here for you, and just wanted to mention it as part of our webinar. Heather, Brendon, anything you want to add before we move on?
No, that was excellent.
All right. I'm going to take Miss No. I'll hand it back over. But myth number 4 is one that's been near and dear to my heart for a while. And if you've seen me in action at the MSP conference, you know last fall, I was pretty on fire about this. And I guess shame on CMS, because they caved. They gave me my way. So basically, myth number 4, you must wait at least 1 year from the date that CMS made a determination and issued that letter saying, hey, we've approved this, to ask them to take another bite at the apple. They used to make us wait even longer, but up until last year, it was at least 1 year. As of April 7th of this year, immediate amended review is available to you. As soon as you get that letter in the mail from CMS, and you don't like what you got, or you think they got it wrong, or whatever, or something has drastically changed, you can do a one-time amended review request. The claim can't have settled yet, and the projected care does have to change. There has to be a change in the amount that would be 10% or $10,000, whichever is greater. They don't want you using this, and it hasn't happened in a while, but they don't want you using it. Let's say a generic drug comes on the market. The last time we saw that, I think, was Lyrica and pregabalin. Anytime that happens, MSA amounts change drastically. That alone isn't a reason to go in. But typically, when a change like that happens and you've had some amount of time, if you do wait a year, you're going to have changes to the fee schedule that will also help you have them take another look. But that's it. Amended review is available now immediately, and I'm super happy about it, because I had, situations where spinal cord stimulators were going in when they shouldn't have been going in. People had already had surgery, and you couldn't tell Medicare to take it out until a year passed. That was absurd. So the agency kind of heard us and made this change. So I'll turn it over to the next myth.
Great. Okay, myth number 5. MSAs are only for workers' compensation settlements. So obviously not true, right? Liability MSAs are applicable in certain circumstances. So what you need to do if you've got a liability claim with a Medicare beneficiary is take a look at the big picture regarding the settlement amount and the beneficiary's future medical needs. We do not have a formal process for review of a proposed liability MSA, or LMSA for short, currently. But Medicare's interest can still be protected with a non-submit indemnified LMSA or other future medical allocation. Also, working with an MSP expert on setting up best practices and determining settlement strategy and liability claims with Medicare beneficiaries is recommended. So I want to talk about here, this came out a while ago, the Stallcup memo came out in 2011. I forget which month and exact date, but it was 2011. I remember that for sure. But this was a memo from Sally Stallcup. She was in the MSP program at CMS, working with MSP matters. And she was continuously asked at that time, do we need to fund a liability MSA? Is it required? Is it expected? She was just being inundated with questions, because now the reporting, the Section 111 reporting had just started up, right, which is applicable across work comp, liability, and no-fault claims. And more MSAs were being done in work comp now, but the question was, is there a requirement to provide for an LMSA? And what she says here, and you'll see it underlined and highlighted, The law requires that the Medicare trust funds be protected from payment for future services, whether it's a work comp or liability claim. There is no distinction in the law. And she also cites the section within the law as well that demonstrates that Medicare's interests should be protected. We've seen over the years a number of times that Medicare has attempted to rule make legislatively around liability MSAs. There's been a number of attempts. All have been withdrawn. It's certainly been not favored by the liability industry to have a regulation around liability MSAs. However, there was a government accountability office study, GAO study done in 2012 that directed the CMS program to issue guidance around liability and no-fault MSAs. So that was in 2012, and still that ask in that GAO study is not filled. So we anticipate that at some point in the future, again, CMS will attempt to rulemake around liability MSAs. But in the meantime, it's fact specific on whether you need an LMSA. But as a conservative approach, we recommend that parties create a future medical plan where a plaintiff is going to require future medical care, regardless of the total settlement amount. And even though, as I mentioned, all LMSA rulemakings have been withdrawn to date, we expect that they will bring back a rulemaking, and Medicare does expect that their interests can be protected with an LMSA. There's a number of ways that we can provide for an LMSA. We can go super conservative, a standard liability MSA. We could also prepare an evidence-based LMSA, but reduces care and applies evidence-based methodology to the allocation, resulting in generally a more cost-favorable MSA. We also have a compromise LMSA product here at Sanderson Firm. What we do there is based upon the Medicare regulations, we apprise an MSA that is based upon the raw total of the LMSA, which we then apply a formulaic reduction to, such as accounting for non-Medicare covered expenses, indemnity, attorney's fees, and lien amounts. And that has been helpful. And that's also a fully indemnified product. So to the extent Medicare ever challenges our compromise LMSA, we would stand behind it.
Okay, so myth number 6. So if your organization, by organization we mean if your organization is a no-fault insurance carrier, workers' compensation insurance carrier, or liability insurance carrier, or a self-insured entity, if you're one of those organizations and you have a reporting agent, Section 111 reporting agent, and your Section 111 reporting agent mishandles your Section 111 reporting, then your reporting agent is subject to civil money penalties and your organization is totally and completely absolved. That's not the case. Medicare in its own policy guidance has written, they say, quote, an RRE, a responsible reporting entity, so those organizations that I named off, an RRE may not shift its responsibility to report under Section 111 to an agent by contract or otherwise. The RRE remains solely responsible and accountable for complying with CMS instructions, for implementing Section 111, and for the accuracy of the data submitted. So it's interesting here. I guess I can appreciate maybe someone who is on the outside looking in as maybe generally aware of Section 111 reporting obligations. There's a lot of just terms in the industry. You have your reporting agent, your recovery agent, your authorized representative, your account manager, your account designee. There's a half dozen plus terms, and the reasonable thought is probably, okay, well, there's all of these different roles and responsibilities. So surely, if CMS can point the finger to identify, hey, this person messed up the Section 111 reporting, then surely this person should have the civil money penalty issued against them, and that's simply not the case. CMS is just playing it safe and saying, hey, look, under the law, if there's a Section 111 report and we can issue a civil money penalty, then that penalty is strictly going against the reporting agent and no one else. So a couple of things you want to do from a best practices standpoint. We can hop to the next slide, but number one is certainly you want to, if you're using a Section 111 reporting agent, you do want to make sure that you select your Section 111 reporting agent or vendor very carefully. Just try to screen them very well. A lot of you may be surprised that some entities out there very much treat, or some reporting agents out there very much treat reporting as a I don't know, punch in, punch out, data in, data out. We get data reported. to CMS, and there's no real partnership between them and their client, the RRE. At Sanderson Firm, it's very much a partnership for us, with us and our clients. And so it's not enough just to do the reporting. It's okay. Well, we'll issue monthly reports to the client, showing them where we're seeing issues in the data. Maybe having regular phone calls. Maybe we've identified, hey, you're using Origami or whatever program, and we're seeing that you're getting these disposition codes, which is causing errors and files to be rejected by CMS when the report's being submitted to CMS. So we very much want to make sure that we can address any systematic issues that you have, such that in the future you're not experiencing these issues, and you're much less likely to potentially get the civil money penalty from CMS. So be careful in selecting your vendor. You want to make sure that they're a partner, and it's more than just, okay, we do your reporting and that's it. Lastly, right, like knowing that if there's a civil money penalty, you and you alone, your organization, is going to be responsible for paying that civil money penalty. You may want to ask your reporting vendor, hey, look, do you have professional liability insurance? Do you have errors and omissions coverage, such that if you mess up, CMS is coming after us? So we want to have some recourse in the back end to recover fees if we get a civil money penalty lobbied against us for something that was technically your fault. And then civil money penalties generally, right? We talk about CMPs. So civil money penalties went live last year. They're effectively live right now, right? They went live October 11th of 2024. And civil money penalties are based around untimeliness, so not necessarily accuracy of reporting, but the timeliness of the reporting itself. And so there's two instances where an RRE can have a civil money penalty issued against them. One is late reporting of acceptance of ongoing responsibility for medicals, or ORM, right? So if a claim comes in and you're accepting responsibility for a claim, you've got to report that within a period of 1 year. Also, if you have a TPOC, total payment obligation to the claimant, or a settlement, you're paying a Medicare beneficiary an amount to release liability for the claim, you've got 1 year to report that TPOC, that settlement, to the federal government. If you don't, if you're untimely, there's tiered penalties. All right, so you have that 1 year grace period. If it takes you longer than 1 year to report either the ORM or the TPOC, but you at least report it within a period of 2 years, then for every day that you're late after that initial 1 year period, the daily penalty is $250 per day. For whatever reason, it takes you more than 2 years to report the ORM or the TPOC, but you at least report it within 3 years, the daily penalty doubles to $500 for every single day that you're late. And if for whatever reason you just never reported at all, or it takes you longer than 3 years to report, the daily penalty doubles again to $1,000 per day. There's a total cap on this right now, technically at $365,000, but this does not account for inflation. So with inflation, if you get dinged with one of these CMPs, it's going to be over $500,000. So that's why civil money penalties are so important, and that's why selecting your section 11 reporting vendor is so important as well.
Yeah, I just want to add on one additional best practice that we should have listed on the slide. Obtain an audit. If you are utilizing a reporting agent to do your Section 11 reporting, and you are just now hearing the significant penalty exposure that Brendon was explaining that you could be faced with, obviously obtaining an audit is a wise tool because you might not know if your reporting agent is handling your reporting properly. And we do Section 111 audits here at Sanderson Firm, and for some of our very Medicare savvy clients, we've found some very interesting things in the data that thankfully we've caught, such as not reporting TPOC on a certain line of claims. We've seen it in work comp. It was not being reported on a whole work comp book of business. Can you imagine? So all of these would be over 3 years late, subjecting them to exposure. We've seen it in another audit we did recently on liability claims. There were no TPOCs being reported. So, this is a really good time to get an audit in advance of the civil money penalties, just to make sure everything looks good under the hood and make sure there's no alarming trends, such as not reporting TPOCs wholesome on all of your claims. So,
all right, myth number 7. Oh, before I jump into myth number 7, I just wanted to mention, Brendon talked about that authorized representative. Just so you know, again, the MSP Network's executive committee met with CMS this morning. And, Brendon said RREs are responsible for the accuracy of their data. So CMS naturally just decided to have their EDI reps call up authorized reps to see if the data was accurate. They have reporting agents usually in the mix, and that authorized rep could be like the CFO of the organization. They may not know what goes on at the claims level. So when you have control over who's that authorized rep, that's something else to think about. Maybe make sure it's someone in place who will have knowledge about this, or spend some time educating them. We're working with one of our TPA clients right now to make sure that all of their adjusters are trained up on what to do if a CMP notice comes through the door sometime, starting next year, early next year, and not to panic. It doesn't necessarily mean that anything's actually wrong. It just means that CMS is kind of investigating. And then the other piece to take away from today, again, breaking news, we did ask CMS, hey, it's July. October is going to be here like basically tomorrow. Are you planning on doing a webinar to talk more about what your audit process is going to look like and how you're going to define some of these things? And they are working on it. They are still working on it. The agency itself is going to control those audits. So keep an eye out for that as the year kind of goes on. But we did ask about that today too. Okay. So documentation of attempts to obtain Social Security numbers is not critical. And I'm going to answer a question that you might see in the Q&A during this as well. But it is absolutely critical to document attempting to obtain a Social Security number when you're handling a claim. In the workers' compensation realm, you don't often have a lot of trouble doing this because you have a special relationship with the injured person, right? They're an employee, so you usually already have their Social Security number and all of their other demographic information. You may not have this, though, in the other realms of non-group health plans. That's no-fault claims and liability claims in particular. And people are very hesitant to give up their Social Security number, and rightly so. But it's very important to document your attempts to get this information because CMS codified this in their final rule. So what Brendon just went over, they created a safe harbor. And in order to exercise, the safety of that harbor, you have to follow their process. So again, anything that's untimely in their mind, right, is, late report of TPOC after 1 year, late report of ORM assumption after 1 year. But they said, hey, if NGHP RREs document good faith efforts to collect this information and make a total of at least 3 attempts to get the information, then you'll be protected from a CMP here. So the 2-in-1 rule says at least 2 of those attempts to the individual and their attorney must be via mail or electronic mail. And then you can make a 3rd attempt via telephone, electronic mail, or some other reasonable method, right? Maybe that person is addicted to TikTok and you can get a hold of them on TikTok because they've turned into an influencer post-injury. You'll send them a DM, right? As long as it's reasonable and you're trying to get a hold of the person, document that in your file. And per CMS, should the individual or their attorney yell at you at some point and say, no way, no how, I'm not giving you this information, or they send you an email after attempt 1 and they unambiguously say, take a hike, you don't have to continue those documentation attempts. You do need to document your file, and you want to maintain that information for up to 5 years because that statute of limitations for CMPs is 5 years. So the question that we got earlier in the Q&A said if the plaintiff fills out that form and they check off that they are not a beneficiary, they don't put any of their PII information in it, they sign it, is that enough for our obligation? They did not indicate a refusal that they are not enrolled in Medicare. I would say in this instance, because they didn't put any of their information on there, that's not going to be adequate, unfortunately. You can, try, and we don't have guidance from CMS on this yet. So also let's, keep an eye on this. Brendon and Heather and I certainly will be through the end of the year. We may have a clarification for you by then, but right now it doesn't seem to me that there's enough information on that form for you to document to Medicare that it actually came from that person. Maybe if their signature, though, looks good and they did document the actual refusal, you could try to use it. But it sounds like probably that's in that instance, it might not be enough. If there was additional information that they provided and they called you, or you give them a call back, and you record it and you talk about it and they refuse it, then I think you're good. So you want to do something a little bit more with that one. And then I think there was another question that maybe came up in the chat about what if they're using, through your database investigations, a social security number that belongs to another person. That gets a little bit tricky. I would want to utilize that form. Typically what I saw in private practice is that when somebody's undocumented and they're using somebody else's information, if you give them that form, they or their attorney will outright refuse it and give you some grounds, to document your file. Or there's 2 pages to the document. And I think if we move to the next slide, we have an example of the document on the first page. There's 2 pages to it. The second page allows them to sort of check a box and say why they're not giving you the information. There may be some tricky wording that they could put in there that doesn't say, hey, I'm undocumented and in this country illegally, that they might kind of put some language in there to indicate that they're refusing and why. So that's what you'd want to document. If they confirm verbally that they're not a beneficiary and they're misusing somebody's social security number, document your file appropriately. The flip side of that is I have seen cases where people have used social security numbers and you settle out the claim and that person is a beneficiary, even though the individual that has the injury themselves is not, and an MSA needs to be created then. I've seen that happen. Child support obligations. People use somebody's social security number and that person happens to be a deadbeat parent. I've seen child support payments have to come out of that injured person's settlement for money that they don't know, but they were using somebody's social security number. So do the best you can with what you have. That's what Medicare says. They say you have to make, reasonable attempts in your normal claims handling world. You don't have to twist yourself in knots. Certainly don't behave. There's a Rhode Island case where they, tried a bunch of different iterations of different social. You don't need to twist yourself into knots. Don't do that. But do the bare minimum, document your file, feel comfortable with where you landed. Call us if you have any questions. Happy to answer them. We also do have a social security number lookup tool that is, priced mighty low for you. So if you need help, we'll help you do that too. But yes, just make sure you're documenting the attempt. Consider using this form. This is the official form. It doesn't look great, but it is the official form from the federal government. The plaintiff's attorney should be aware of it. Make sure you're querying these claimants. It's not just people who are 65 years and older or 65 years old or older. It could be somebody younger than that. And then, make sure that you're, being consistent in how you apply this. But great questions, everybody. Thank you for throwing them out there. It's really good. And if we missed anything, we can grab it at the end. As Heather said, we'll have time for more questions. But moving on to myth number 8.
Okay, myth number 8. Myth number 8 is that Section 111 reporting and Medicare conditional payments sort of exist in silos and don't impact each other. That's not the case at all. In fact, they're very much intertwined. So you should know that Medicare's conditional payment recovery contractors, which are the CRC, which handles workers' compensation and no-fault claims with open RRM. And then the BCRC is the other contractor that works with conditional payments for liability and work comp claims where settlement has been reported. They actually use the Section 111 data to identify conditional payment recovery situations. That was the bulk of the majority of the reasoning behind Section 111 was before Section 111 reporting started, Medicare was in the dark as to these settlements with Medicare beneficiaries, and effectively we're not recovering conditional payments like they are today. Now, this gives them the information. So they will use the ICD codes provided and take a look at those to determine what's related and what they should seek recovery for. So if the responsible reporting entity reports incorrect codes, Medicare may seek recovery for those codes. Or if the RRE reports it still has ongoing responsibility for medical, Medicare will continue to assume that it does not have primary payment responsibility, meaning they're denying care to the Medicare beneficiary. This is a problem. The ORM is one of those areas of Section 111 that should be heavily monitored and should be terminated as soon as it's reasonably expected and appropriate to do so. Even though civil money penalties will not be assessed for incorrect coding or flagging, it will still result in conditional payment issues. And Medicare's program, and particularly the CRC, their technology already has enough issues. They've told us this. They say their technology, particularly at the CRC with their grouper algorithm, it will still grab unrelated codes. I mean, there's a reason why, our conditional payment success is so high because typically Medicare throws in everything with the kitchen sink, but your duty as a payer of a claim with a Medicare beneficiary is to report accurate codes. So make sure that your codes are reported to Medicare as specific and accurate as possible. Do not over-report ICD codes simply because they're listed on a medical record in the beneficiary's claim file. That's the worst thing you can do. And if you have a valid ORM termination basis, such as the statute of limitations, the treatment is concluded, beneficiary death, or a settlement that closes out medicals, report the ORM termination to avoid unnecessary conditional payment disputes and appeals. All right, let's keep it going because I think we have two more myths and some other information to provide, and we want to take questions. We're at 2:21, so.
Okay, perfect. So myth number 9. So Section 111 reporting and Medicare conditional payment handling responsibilities may be shifted onto the claimant slash plaintiff and their attorney. So like two little separate things here. So let's kind of take this one by one. We'll start with Section 111 reporting. So Section 111 reporting. So only RREs, responsible reporting entities, or their agents have the capability to report via Section 111. I think a lot of the times in the industry, and I'm probably guilty of this myself, we sort of tend to overuse the term reporting. There is, how I call them, two types of reporting, and I don't know if I made these terms up or kind of saw these along the way, but I sort of internalized them as there's soft reporting and there's hard reporting. Soft reporting occurs when a plaintiff or a claimant, or typically their attorney, contacts CMS and say, "Hey, CMS, I've got this ongoing claim," because the attorneys have done this dozens, hundreds of times, right? They call CMS, they want CMS to know, such that CMS can open a conditional payment recovery file, so the attorney knows, okay, this is how much I'm potentially getting paid. This is how much my client's getting paid. This is how much we have to reimburse the federal government. They're just doing like a little accounting of sorts. That allows CMS to open a recovery file for a conditional payment lien, right? But that does not then satisfy the insurance carrier's responsibility to, on their own, make a report of ORM or TPOC to the federal government. Because I see this sometimes where primary payers reach out to me and say, "Hey, look, it's great. Claimants Council reached out to CMS. They got the lien. It's all good. It's been reported." That's not enough. You still have an obligation to report via Section 111. Hard report. If you don't hard report, then you're looking at civil money penalties. And the second one, conditional payment handling responsibilities can technically be shifted onto the claimant or the plaintiff or their attorney via the, for example, settlement or release agreement. However, just know that if they don't follow their contractual obligation to reimburse Medicare for the conditional payment liens, then Medicare has the right to pursue the insurance carrier, the primary payer, or any party that receives a primary payment. So sure, you can have the best language in the release saying, "Hey, look, we, the insurance carrier, don't want to deal with this Medicare stuff, this TRICARE stuff, whatever, all the liens." And the language can say that plaintiff and claimant agree to indemnify, defend, and hold the insurance carrier harmless from any and all liens, right? That's fine, and you should have that language in there if you're allowing the other party to satisfy the liens. But just know that if they don't pay, Medicare can, file a lawsuit against you for non-reimbursement of conditional payment liens. And a quick point on this, a lot of the times I see primary payers, they shift responsibility in the release agreement for conditional payments to the claimant and the claimant's attorney. Then they sort of close their eyes. They say, "Oh man, I really hope these liens get paid." You don't have to do that. You can trust, but verify. You can reach out to us. We can do this for you. You can contact CMS, review the Medicare Secondary Payer Recovery Portal, make sure that CMS's lien was actually reimbursed. It's a little bit different for Medicare Advantage plans and private Medicare plans because a centralized portal doesn't exist. We can still reach out to them and confirm, "Hey, for this case ID or for this case, has your lien actually been satisfied?" So best practices here for Section 111 reporting, just recognize that it's solely the responsible reporting entity's responsibility to report via Section 111. As I said earlier, screen your reporting agent, make sure that they're truly your partner. And lastly, on the conditional payment front, even if the settlement agreement holds the claimant or the plaintiff responsible for reimbursement, run your own conditional payment lien search, trust, but verify.
All right, Ms. 10, I will spend mere seconds on this because it is what it is what it is. Medicare Advantage plans, this missaid, has less recovery rights than traditional Medicare. It's not true. In fact, they have access to double damages. That's really all they have access to. Traditional Medicare will try to come after you and they'll get it through the Department of Treasury. MAPs don't have that, so they try to sue you for double damages. We've got the citations here. Please treat these guys just like you treat traditional Medicare and make sure that you clean them up. They need to get paid or they will sue you for double damages. Watch out for the 3 to 4 year statute of limitations thing at the bottom too. Traditional Medicare, it's 3. Some rulings have said 4 in other jurisdictions for MAPs.
Essentially, the Medicare Advantage plans are certainly a concern just as much as traditional Medicare, and making sure these are taken care of. If you see that the Medicare lien is 0, but you know the person's been seeking treatment elsewhere, it's probably a sign that Medicare Advantage plans have paid. So we want to make sure that you're checking for both Medicare and Medicare Advantage plan conditional payments. If you're utilizing a vendor for your reporting and they're not passing back the enrollment data on the Medicare Advantage and Part D plans too, that's a problem. Since 2021, this information has been passed back pursuant to the PAID Act, so you should be receiving that information. Okay, so just want to make sure everyone's aware we've decided that August is a crazy time of year and all the kids are going back to school and everyone's shifting out of summer mode, and we're taking a break in August from our webinar, but we will have a webinar in September. So please stay tuned to our webinar announcements. You can also automatically be enrolled in all Sanderson Firm webinars if you email spotlight@sandersoncomp.com. Just want to make sure everyone is aware we are a full Medicare Secondary Payer Services vendor. We specialize in all different types of Medicare set-asides, Medicare, conditional payment lien services. We also are a Section 111 reporting agent, and we also do Section 111 audits. We also have a Social Security number lookup tool, as mentioned earlier. As a full law firm, we also can provide legal advice, best practices for your organization. Just want to briefly mention MSP College. We have 2 educational programs fully online, which you can learn more about MSP. MSPA is our broad designation when you want to learn all things MSP. It's comprised of 9 courses covering everything from Section 111 reporting to MSAs to conditional payments. You can take these programs at your own pace. At the end, you receive a certificate and a designation in this educational program. So MSPA is more of your broad sense. And then we also have the Medicare Set Aside Certified Planner, or MSACP for short, which is more focused on those that want to understand Medicare Set Asides more in depth. You can find out more about these programs at mspcollege.com. We are at the top of the hour. I believe we might have time for one question, Annie. I think we've got maybe 1 minute. Do you see any other questions in there that we need to address? And by the way, our contact information is here on the screen, and please feel free to reach out if you have any questions that we didn't get to during the presentation.
If you can hear me, yes, I'm typing a response right now. The question was just, do we know why CMS or medical providers will ignore the codes that are reported and deny treatment? Provider's office. They're reading the screens wrong, but Medicare did release an updated MedLearn alert, so we'll make sure to send that out along with the deck when this is over, and that's what you and the claimants should use to give to the doctor's office so that they read the screens properly. So yeah, it's just usually the doctor's office being scared.
Okay, well, we're at the top of the hour. I want to thank everyone for their participation in today's webinar and thank my fabulous panelists, Brendon and Annie. We'll be back in September with more content. Wishing everyone a great rest of your summer, and we'll see you again soon.